Terrific. Thanks very much, Laura. And yeah, if you could just move to the next slide, please. Thank you. It's terrific. So good afternoon, everyone. My name's Adrian Hawkes. I'm the enforcement team leader for the timber regulations team at the Office for Product Safety and Standards in the UK. Today, I just want to talk you through a few key areas relating to our regulatory area. So firstly, I want to talk through the framework of the UK timber regulations and set the context for how we enforce this legislation in Great Britain. I'll also look at what rules are in place in Northern Ireland and what the changes mean for operators throughout the UK. So I'll then talk through some of the exemptions to the timber regulations, but focusing mainly on flagged licenses, which is probably the most relevant for this discussion today. And then finally, I will talk through some aspects of our approach to enforcement as the competent authority in the UK. And I'll look at how we identify a new area of investigation, how we engage with businesses, and also a little bit about how we assess and test the claims that are made by operators with regards to their due diligence systems. So next slide, please. So just want to start by looking at the framework of the timber regulations. I understand that the session yesterday covered in some detail the information relating to the framework and the requirements of due diligence in more detail. But I just want to cover some of these today, more from the point of view of being able to then set the context for some of the later points that I'll want to make in the presentation. So just to recap, the purpose of the UK timber regulations is to prevent illegally harvested timber and timber products being placed on the market in GB. Not all timber products fall within scope of the regulations, and the guidance to UKTR, which was published at the beginning of this year and is available on our website, that guidance lists the products by commodity code that are included in the regulations and within scope of the regulations. And those two elements are identical, I suppose, to what the requirements were under the European timber regulations. So EUTR, the purpose was to prevent illegally harvested timber being placed on the market, and the list of products that are within scope are identical at the moment to what they are under EUTR. So the regulation obviously creates obligations for two groups, for operators and traders, and an operator under UKTR is a business that places the product on the GB market for the first time, whereas a trader is a business that purchases a product that has already been placed on the GB market. And I'll go into that in a little bit more detail shortly. There are three instances where a product may fall outside the scope of UKTR. Or a CITES permit, or where a product is from recycled material. As I indicated earlier, I'll talk about these exemptions in some more detail later on. So next slide, please. So as I said, UKTR creates obligations for two categories of people: operators and traders. Operators are required to undertake due diligence when placing a timber product on the GB market for the first time. Traders, on the other hand, must be able to identify the operator or the trader who supplied the product to them. I won't go into that in more detail because I think that's probably been put across previously, and people are aware of that and what the requirements are there. But I really just want to include it here to emphasize that the definition of an operator and a trader and the obligations that they have aren't any different under UKTR from what they were under EUTR. The only change is that the scope of who is an operator under UKTR has expanded now to include someone who imports a product from the EU. Next slide, please. So looking very briefly at the due diligence system, operators under UKTR have an obligation to undertake due diligence on timber products that they place on the market for the first time. The due diligence requirements under UKTR have three components. access to information, so understanding your supply chain from the point of harvest to placing the product on the market. A risk assessment on the supply chain to assess the risk of illegally harvested timber entering the supply chain. And then finally, where that risk is not negligible, undertaking risk mitigating actions to ensure that that risk is negligible. So again, the structure of the due diligence system and the components of that due diligence system have been addressed already in another session or in the earlier session. But the point I want to emphasize here again is that carrying out due diligence under UKTR has not changed from the process under EUTR. So for operators in GB, the scope of this requirement has expanded in terms of having to undertake due diligence on supply chains which run through Europe or from Europe. But the actual components of due diligence and the threshold of due diligence has not changed. Next slide, please. So I want to look at a little bit how we enforce the timber regulations across all of the United Kingdom. So the first part there obviously dealt with UKTR, but I want to discuss what the regulatory framework and how the regulatory framework in GB is different from that in Northern Ireland. So since the end of the transition period, that's from the 1st of January this year, UKTR came into effect. However, UKTR only has effect in Great Britain, so England, Scotland and Wales. In Northern Ireland, EUTR continues to be the relevant regulatory framework there. In practical terms, the Office for Product Safety and Standards is still responsible for the enforcement of the regulations throughout the whole of the UK. So this means that in Great Britain, we're responsible for enforcing UKTR, whereas in Northern Ireland, we're responsible for enforcing EUTR. Next slide, please. So I just want to run through in a little bit more detail what the impact is on having UKTR in GB and EUTR in Northern Ireland. And to illustrate this, it's perhaps useful to look at the following 4 scenarios. So in the first instance, where timber moves from Great Britain to Northern Ireland, so if a business in Northern Ireland brings in a timber product from Great Britain, the business in Northern Ireland will need to undertake due diligence to ensure that they are able to comply with the due diligence requirements under EUTR. And this modifies the position that was in place prior to the end of the transition period and means that there's a new process in place for businesses in Northern Ireland to follow if they're sourcing products from a company in Great Britain. The second scenario is timber moving from Northern Ireland to Great Britain. So if a business in Great Britain brings in a timber product from Northern Ireland, there will be no new checks. This is to give effect to the Northern Ireland Protocol, which says that there will be no new checks on goods moving from Northern Ireland to Great Britain. And this replicates the position prior to the end of the transition period and means that there's been no change following the end of the transition period if a business in Great Britain is sourcing a product from a company in Northern Ireland. But I think it's important to just emphasize there that the direction of travel of timber products between Great Britain and Northern Ireland, and depending on which way it's going, there are different rules in place for the business placing that on the market. If it's moving from Northern Ireland to Great Britain, there's no requirement on the business in Great Britain to undertake due diligence under UKTR. Whereas if it's going from Great Britain to Northern Ireland, there is an obligation under the EUTR for the business in Northern Ireland to undertake due diligence. The third scenario is timber moving from the EU to Great Britain. So if a business in Great Britain imports timber from an EU member state, that business is an operator and will need to undertake due diligence to comply with the requirements of UKTR. So this modifies the position that was in place prior to the end of the transition period and means that there's a new process for businesses in Great Britain to follow if they're sourcing a product from the EU. And finally, timber moving from the EU to Northern Ireland. If a business in Northern Ireland buys timber that has already been placed on the EU market, the business in Northern Ireland is considered a trader, is considered to be a trader. And that's because the EUTR is the relevant legislation in Northern Ireland for the movement of timber, and treats the relevant market as being the European market for those purposes. So that essentially replicates the position prior to the end of the transition period, and means that there was no change following the end of the transition period if a business in Northern Ireland was sourcing a product from a company in the EU. So next slide, please. So to summarize the position of UKTR in practical terms, if you're an operator importing timber from outside the EU, there's been no change to your obligations under UKTR compared with what your obligations were under EUTR. Under EUTR, you needed to have in place a due diligence system which assessed the risk of illegally harvested timber entering your supply chain. And under UKTR, you have to have in place a due diligence system that assesses this risk. In both cases, you had to ensure that that risk was negligible or refrain from placing the product on the market. For businesses in Great Britain who purchase from European countries, under UKTR, you are now required to have a due diligence system in place. Previously, under EUTR, you were only required to have documentation to show traceability of the product, but now you have to have a full due diligence system in place to the same standard as discussed already. That is, to ensure that the risk of illegally harvested timber entering your supply chain is negligible. It's important to be clear that under UKTR, the responsibility for this due diligence system rests with the operator in GB. So your supplier in Europe may already have undertaken due diligence to comply with EUTR. And as I've said, the elements of due diligence and the threshold for due diligence in UKTR is the same as it is under EUTR at the moment. However, it's not sufficient for a business in Great Britain to simply refer to the fact that they've purchased timber from a European supplier and to say that they would have therefore, the European supplier would therefore have had to comply with the due diligence requirement, and that you can rely on their actions in the EU as being equivalent of their own actions here. The requirement under UKTR requires that operators have access to this information and to be able to make this information available to the competent authority upon request. So you must satisfy yourself that your supply chain, all the way back to the country of origin or the place of harvest, is compliant. You might be able to get documentation supporting that from your supplier, and if they've carried out their responsibilities as an operator in the EU, that may be a more straightforward process. But the responsibility is on the operator in GB to have that information and to be able to present that upon request. And finally, I just want to speak very briefly about the variation of risk within the EU. And I understand that more will be spoken about this later as well. But really just to say that when the UK was a member state of the EU and part of the single market, once a product had been placed within the EU market, it could then move freely within that without distinction of where it came from. However, now that the UK is no longer a member state of the EU, we don't treat the European market as one homogeneous area without any variation in risk. So a risk assessment will need to account for localized risks within the EU area. And it's not sufficient just to look at timber as being low risk just because it comes from the EU. In some cases that will be justified, but in others the risk is much higher and it will require more and different mitigating actions. Next slide, please. So as I mentioned earlier, there are certain circumstances where you place timber on the market in GB, but under UKTR are exempt from having to undertake due diligence. So I just want to talk about the following three exemptions. So flagged licensed timber, timber which is accompanied by a CITES permit, and recycled material. In each of these cases, I think it's important to note that our position and the exemptions that exist under UKTR mirror those that exist under EUTR. But it is important to note, particularly with flag licenses, what that means in practice. So next slide, please. So with regard to flag licenses, I think it's worth just moving one step back a little bit and just speaking briefly about how they come into place in the first place. So a voluntary partnership must be in place before a flag licensing system can be set up. Both the EU and UK have voluntary partnership agreements with Indonesia. The voluntary partnership agreement between the EU and Indonesia was ratified when the UK was still a member of the EU. And as a member state of the EU, the UK was party to that agreement. However, following the end of the transition period, a separate voluntary partnership agreement came into effect directly between the UK and Indonesia. Under both voluntary partnership agreements, so the voluntary partnership agreement between the EU and Indonesia and the voluntary partnership agreement between the UK and Indonesia, there is a mechanism for issuing flag licenses. And under both UKTR and EUTR, if timber is placed on the market and is accompanied by a flag license, the operator placing that product on the market is exempt from undertaking due diligence on that product because the flag license assures the legality of the timber. However, it's important to note that the exemptions under UKTR and EUTR are the result of separate agreements with Indonesia and only apply on the imports directly from Indonesia to UK under UKTR or on imports directly from Indonesia to the EU under EUTR. So next slide, please. So it's perhaps useful to look at what this means in practical terms using the following scenarios. So if we take, obviously in each case, Indonesia is the starting point for each scenario, that's the point at which the flag license is issued and accompanies the timber as it's exported to the relevant market. The flag license will indicate which country the product is destined for. So if, as in the first case, it goes to the EU, the flag license is verified by the relevant competent authority prior to it passing through customs. If a business in Great Britain then purchases that product from the business in the EU and places it on the GB market, the GB operator must undertake due diligence, as the exemption under UKTR only covers products and imports directly from Indonesia. So due diligence will be required, though the flag license may form part of that due diligence. So you would need additional information on that part of the supply chain, so between the product being cleared into Europe and it then clearing customs in Great Britain. You would also need to account for information that is required in a due diligence system and which may not be included in the flag license. So for example, a flag license doesn't necessarily list all the species that are included in the timber that you're placing on the market. And if that's the case, then you would need to obtain that information before you place it on the market in GB, because under the due diligence requirements in UKTR, you need to be able to identify all species within the product. Looking at the second scenario, where products that are exported from Indonesia to GB, OPSS will verify the license prior to it clearing customs, and as we have in the past, and the operator placing it on the market in GB is therefore exempt from carrying out due diligence, again because under UKTR, timber which is covered by the flag license arising from the UK-Indonesia VPA is considered legal. However, if a business in Northern Ireland then imports that timber from Great Britain, they will need to undertake due diligence, though again, the flag license may form part of that due diligence, as I described in the previous scenario. The final scenario is where the timber lands in Northern Ireland directly from Indonesia. And in this case, the Northern Ireland business would verify the license with OPSS prior to it clearing customs. If a business in Great Britain then purchases that product from the Northern Ireland business and places it on the GB market, there would be no requirement to undertake further due diligence. And again, that's going back to the terms of the Northern Ireland Protocol, which assure that no new checks will be made on movement of goods from Northern Ireland to Great Britain. The business in Great Britain would really only have the traceability requirements for trader to be able to identify who they purchased it from. Next slide, please. So timber covered by a permit under CITES is also considered to comply with the legal requirements of UKTR. And in those cases, importers don't need to undertake due diligence on this timber when placing it on the GB market. I won't go into too much more detail about this just now, but further information is available on the gov.uk website and the CITES.org website. And in the UK, the Animal and Plant Health Agency is responsible for verifying permits attached to imports that are coming into the UK. Next slide, please. So with recycled material, so I just want to look at this, and when an operator placing it on the market is exempt from undertaking due diligence. So our starting point is that if a product is included within the scope of UKTR, then due diligence is required on that product. As we've said, an exemption to this applies under UKTR, and again, this mirrors the exemption under EUTR for products that have completed their life cycle and would otherwise have been discarded as waste. So it's important to know that it doesn't. There are, limitations and restrictions around the definition of that. So it doesn't apply to byproducts of a manufacturing process, for example. So the offcuts of timber that are used for a new product are not covered by that exemption. And it's also not interchangeable with products that are simply second-hand and recycled only because they've changed hands. So one example of something being, merely second-hand is wooden barrels that are used to distill alcohol. These might be bought, and very often are, second-hand, but they're still being used as they were originally intended, and so they don't fit within the exemption of a product that's reached the end of its life cycle and would otherwise have been discarded as waste. A good example is perhaps something like floorboards that have been reclaimed from a house that was being demolished and then repurposed as furniture or something. Those are clearly products that timber products that would have otherwise been disposed of. As I said, the starting point for us is that products are within the scope of UKTR and are subject to due diligence requirements, and the onus is on the operator to demonstrate that the exemption applies to them for recycled material, and they would need to provide evidence that the product had reached the end of its life cycle and would otherwise have been discarded as waste. But I won't go into that in more detail now, but further information on that is available in our guidance document for UKTR. So next slide, please. So I just want to talk now a little bit about our approach to enforcement more generally, and specifically I just want to talk about how we choose an area for investigation, how we engage effectively with business, and finally some practical points about how we assess a business's due diligence system. So next slide, please. So to begin with, our approach to enforcement usually starts with one of two main inputs. So the first of these is the overall risk profile, and that might be information about a country of origin, It may be general information about a heightened risk around a supply chain, or something relating to a particular product that might be inherently high risk, such as composite products, for example. The second key input is intelligence, where we have specific information that helps us identify an area of concern. So that might be from customs data, or it may be from substantiated concerns reports from third parties who identify an area of concern, or it may be revisiting businesses who were previously found to be non-compliant with the regulations. So in reality, whilst these are two separate inputs, they're often used in conjunction with one another to build our understanding of the landscape. And so where we may have a general appreciation of risk and an understanding of the risk profile, we would then look to verify this and test it with intelligence and specific information. And I think it's also important to note that as the UK competent authority, we need to filter and assess these risks against the impact of against the impact on the UK. So illegal logging is obviously a global problem, and there can be issues which are of a much more serious nature. But if it's not entering UK supply chains, it might not be the first thing that we focus on. We need to be realistic about which issues we are addressing, and they need to be issues that we have control over in order to make an impact on that. So next slide, please. So I think it might just be useful to give you a bit of a flavour of what this approach looks like in practice. And I think to do that, just to run through a few examples of our recent enforcement activity. So to begin with, the Fuelwood project, in 2015, in November 2015, the Ukraine government implemented a ban on roundwood exports. And there were subsequently allegations that exports of fuelwood were being used to circumvent this ban. This had been picked up in a number of reports, including Earthsight and the EU Commission report, as well as a statement from the Ukraine government. So we undertook a scoping exercise to establish which companies in the UK had been importing products under the Fuelwood Commodity Code to the UK. And we then engaged with these businesses to determine whether or not the import of fuelwood had been done to circumvent the ban on roundwood. So this is an example of where we've had information about a heightened risk profile, and where we then attempt to match specific information and the data relating, to match specific information against the more general risk that's been raised with us. We've also undertaken a couple of customs data projects as well. So we recently received, or last year received, data from the Belgian and Dutch competent authorities on UK registered businesses who were importing through Belgium and the Netherlands. And this was a good area for us to focus our engagement on for two reasons. Firstly, to see whether or not there was a deliberate attempt to avoid detection. So if the competent authorities hadn't shared that information with us, so the competent authorities in the Netherlands and in Belgium, we wouldn't have been able to identify these imports, and we wouldn't have been able to follow up with the businesses in the UK. Also, it was undertaken in the lead up to the end of the transition period. So it was a good opportunity for us to engage with businesses whose supply chains ran through EU countries as well. Third area that I just wanted to mention was the flake licensing project. And as I mentioned earlier, if a timber product is imported from Indonesia, it needs to have a flake license accompanying the product, and the license needs to be submitted with us to us for verification prior to it clearing customs. So we had reviewed data from the HMRC, which indicated that a number of companies had imported timber products from Indonesia, but had not submitted these licenses for verification. There was something in the order of 200 companies that had not done this. So we're in the process now of contacting these businesses to ensure that, firstly, they understand the requirement to have a flag license for that product, and secondly, that they understand the requirement to submit that license for verification prior to the product clearing customs. And then finally, the risk register. The risk register is more of an open project, and it's really about trying to follow up with businesses that we have previously found to be non-compliant, or where we receive substantiated concerns about specific supply chains or specific businesses, to make sure that we're able to engage with them and to follow up on the state of compliance within those businesses. Next slide, please. So I guess once you've had a look at what the risks are and what the higher value areas to address are, one of the questions is, how do you engage most effectively with businesses? And I suppose I just want to draw attention to the two main ways that we engage with businesses in our role as enforcing the regulations in the UK. So firstly, we engage through awareness raising activities, and secondly through enforcement activities. So firstly, with regard to awareness raising activities, I think it's always important to remember that we are, like, the Office of Product Safety and Standards is part of the Department of Business in the UK. And so one of our aims is to ensure that businesses are able to function as a productive part of the economy. That doesn't detract from their obligations to comply with the regulations, but it does mean that we have an important role in supporting businesses to comply with the regulations. So in that context, we ensure that we dedicate a good amount of time to awareness raising activities. We regularly run or participate in workshops which are designed both to support participants understand what their obligations are under the regulations, and secondly, to provide an opportunity to ask questions and clarification about our activity. We've run workshops that are general in nature or focus specifically on a particular sector or on a particular product. And around the end of the transition period, we ran and participated in several workshops that related to the changed arrangements following EU exit. We also try to support businesses by ensuring that the information on our website is clear and up to date. So we have a presence on LinkedIn, Timber Legality Forum, and this enables us to communicate key messages quickly and responsibly to stakeholders. At the beginning of this year, we also published a new guidance document for UKTR, and again, this is available on our website. The other side of our engagement with business is obviously through enforcement visits. And I've already spoken about how we identify areas to investigate and some of the areas that we've looked into more recently. But I just want to talk through a little bit more about what that looks like when we engage with a business directly. So when we initiate an engagement with a business, we will identify a specific product that they have placed on the market, and we'll request to see the due diligence system that they had in place with regard to that product. Our preference is to arrange a time to visit the business at their premises and review that due diligence system on site. And we do that because we find that a face-to-face meeting is generally more productive and more fruitful. If we, for example, are on site and we request to see a specific piece of documentation, it's much easier to do that where the business is, at the business's premises, and they're likely to be able to produce that more easily. However, if we can't visit, we may ask the business to send their due diligence system to us electronically, and we can review that remotely. When we review the due diligence system, if we find that the due diligence system is non-compliant, we'll advise the business that there's been a breach of the regulations and explain the reasons why. We continue to engage with them as part of our enforcement activity, but we also then start to work with them to provide more direct guidance and support on what they need to do in order to comply in the future. I'll talk in more detail shortly about the sanctions that are available to us in the event of non-compliance. But before I do that, I just want to speak briefly about how we test some of the claims in an operator's due diligence system, and look most specifically at documentation and product testing. So next slide, please. So when we assess an operator's due diligence system, there are two key assurances that I'd like to talk about in more detail are document verification and product testing. So an operator's due diligence system will invariably include several pieces of documentation, ranging from harvest permits to transport documentation to third-party certification. I want to look at this obviously from the point of view of a regulator, but the approach that we take may overlap with how operators should interrogate and challenge the information that they're given by their suppliers when they're putting together their due diligence system. So when we're assessing the documentation that has been provided to us by an operator as part of their due diligence system, it's important for us as a regulator to understand two things. Firstly, which documents are required within a particular supply chain. So that's another way of saying what are the legal requirements for particular countries. And secondly, are there any issues with the validity or the integrity of these documents? So with regard to the first aspect, our starting point is always going to be making sure that we have an up-to-date understanding of what documents are required in the country of harvest, whether that's harvest permits, forest management plans, and so on. Obviously, with some countries, we have a more familiar understanding of the requirements just because we've engaged with more businesses who have supply chains running through them. And this might be the same for operators as well. But the rules in individual countries can change over time. And it's important, therefore, that you keep up to date with the requirements and check what those requirements are, even if you think you know already. There's obviously a very wide range of resources online that make this information available. Obviously, Preferred by Nature's Sourcing Hub is an excellent point of departure in understanding the legal requirements in timber producing countries, as well as the risks associated with these. Other websites as well, such as official government websites, are often very useful in terms of providing up-to-date information about what documentation is required, as well as what some of that documentation looks like. And having examples of the documents from an official source is very useful for when you're then comparing these against the documentation that your supplier has provided. Things can look official even if they're not, and if you have something to compare it against that does come from an official source, that can make your life a lot easier. So once you've looked at the actual documentation, I guess the next thing to check is the integrity of the documentation and whether or not there's anything that compromises its validity. So as I said, it's obviously useful if you have an official example of the correct documentation to compare it against. But even where you do, it's important to check some aspects of the documents. So for example, if there's a risk of corruption in the country of harvest, you may wish to check the name of the officials who issued the permits. So a search online will sometimes reveal the names of individuals who've been involved in corruption. And if that name appears on your documentation, then you've obviously got a risk there that you need to address. It's also important to check the validity and the scope of documentation. So one of the things that we do when we look at an operator's due diligence system is piece together the timeline and the supply chain according to the documentation and make sure that the dates hang together. So just basic things like, making sure that the harvest permit was issued before the transport documentation and so on. Also things like checking that the harvest permit covers the species that you have in your product is important. Also with third-party certification, it's really important to make sure that the scope of the certification covers your product if you're intending to rely on that as a risk mitigating tool. So to use FSC certification as an example, sometimes we're presented with just an FSC certificate to cover a link in the supply chain, and on the face of it, it all looks fine. It might have been issued a couple of years ago and it still looks as though it's valid for another 3 years or so. However, it's always important to check these certificates online and to do that periodically as well. So if you go onto the website for FSC, you can check a number of important things. You can check, is the certificate still valid? So sometimes the certification may have been terminated or suspended, but the information on that may only be available if you check online. Secondly, does the certification cover the product that you're importing? Again, online, the information about the certificate will tell you which products are covered by that certification. And if your product isn't listed there, then it isn't covered by the certification. Finally, you can check whether or not the certification covers the species in the product that you're importing. Again, online, there's a list of which species of timber are covered in the certification that's issued for that link in the supply chain, and you need to make sure that your product and the species in that product is included in that. Next slide, please. So another way that we have to verify an operator's claims, and again, this is something which is open to operators to do themselves, is to undertake scientific testing on the product that they've placed on the market. So one of the most obvious risks in a supply chain is that illegal timber has been laundered and mixed with legal timber. And the obvious challenge here is that you and your supplier might have the correct documentation, or at least the legal documentation relating to that supply chain, and everything on the face of it at least looks to be in order. However, if an illegally harvested piece of timber has been substituted in the supply chain, scientific testing can be one way of addressing that and ensuring that that risk is mitigated. So by using scientific testing, you can verify the origin and the provenance of a piece of timber. So if you have documentation showing that the timber is American oak, for example, we can undertake testing to verify those claims. We use two main types of testing: anatomical, which can verify the genus, so whether it's oak, eucalyptus, or teak. But there's also isotopic testing, which, by looking at the chemical signatures in the timber, is able to pinpoint the species and also tell you if your oak came from the US or Russia or China. That's dependent to some degree on whether or not there's reference material available, but if there is, it can really narrow down the actual location of where the timber was harvested. And in cases where good reference material is available, the level of precision can be down to particular regions, and in some cases even forest concessions. The obvious benefit of this process is that it allows us and you as an operator to verify where the product that has been placed on the market comes from, and whether or not that matches the documentation that's been provided as part of your supply chain. Next slide, please. So finally, I just want to speak briefly about what we do in the event that a business does not have in place a compliant due diligence system. So if we find that a business has not complied with its obligations under UKTR, there are basically three responses that we have to that. So firstly, there's an advisory letter, and this is usually used in cases where there's been a first breach and the breach is relatively minor. So it's a letter which gives guidance on what the business should do to ensure compliance in future, but the letter really remains between us and the company that we're issuing that letter to. The second response that we have is a notice of remedial action. And this is issued when the breach is more serious. There may have been a previous instance of non-compliance, for example, or the supply chain is much higher risk, and there should have been significantly more work done on assessing that effectively. There's no financial penalty associated with the notice, but it is published on our website and is publicly available. So the sanction obviously has a reputational impact on the operator that has been issued with the notice of remedial action. And the final, I should also say, the notice of remedial action also requires the business to take steps to remedy the breaches within a certain period of time. The final action that we have available to us is prosecution, and to date we've had 3 prosecutions, each of which have been successful. And this has been undertaken where there's been a sustained refusal to implement a compliant due diligence system, or where the notice of remedial action has been breached. So the maximum fine is an unlimited fine or 2 years imprisonment for the directors of the company. So far, it's the prosecutions that we've had, they've been limited to fines. There hasn't been anyone who's been imprisoned as a result of a breach under UKTR or EUTR as we were enforcing before. So hopefully that has helped to sketch out some of the regulatory framework that we're working in at the moment and how we enforce the regulations in the UK. I understand that will be questions after the next presentation, and I look forward to being able to answer some of those then. But for me, I'll pass back now to Laura. Thank you very much.